Good afternoon. My name is Felda Young, and I am an HK45 committee member and a senior associate at GOAL. Welcome to this year's HK45 annual update. We are a group of young practitioners in Asia and beyond with the aim to promote the use of arbitration in Hong Kong as a seat. Thank you for joining us this afternoon for a discussion of very interesting topics with our esteemed speakers. First, we'll hear from Diana Xiao, a senior associate at Clifford Chance Litigation and Dispute Resolution Team. Diana will cover the Hong Kong mainland arrangements and give us an update on the interim measures. After that, we'll hear from Paderi Deshbhai, a senior associate in Minter Ellison's Dispute and Competition and Insurance Team. Paderi will give us a summary of the key cases which has occurred in the past 9 to 12 months. We'll then hear from Sophia Tong, an associate at Sidley Austin. Sophia will lead the discussion on the Green Pledge and give out some tips and pointers on green arbitration. Last but not least, we'll hear from Hugh Kam, a former HK45 committee member and a barrister at Plowman Chambers. He will lead the presentation on enforcement cases in Hong Kong and the recent red decision by Madam Justice Mimi Chan not to enforce an award. We'll record the session so that those who have missed the live event can watch it later. We'll also have some time for questions and answers at the end when all the speakers have spoken. So if you do have any questions, please use the chat function to let us know. I'll pass the floor to Diana.
Thank you, Felder, and thank you to Hong Kong 45 for the opportunity today. So as mentioned, today I'll be speaking about two topics. The first is an update on the implementation of the Hong Kong mainland China arrangement on interim measures, followed by a brief explanation of the key provisions under the supplemental arrangement concerning mutual enforcement of arbitral awards between mainland and Hong Kong. So on to the next slide. I believe that the Hong Kong mainland China interim measures arrangement is a topic that everybody should be relatively familiar with, and it's the subject of previous presentations, including at HK45, so I won't go into the specifics of that other than to sort of give a very brief overview of what it is. So the arrangement came into effect on the 1st of October 2019. It allows parties to certain Hong Kong arbitration proceedings to apply to mainland Chinese courts for interim measures in aid of those pending arbitration proceedings. The mainland Chinese courts are empowered to grant 3 different types of interim measures, being preservation of property, preservation of evidence, and preservation of conduct or interim injunctions. An application can be made before or after the relevant arbitral institution accepts a notice of arbitration. And currently, the arrangement extends to arbitration seated in Hong Kong before 6 arbitral institutes, including the HK45. So moving on to the next slide. The next series of slides will just be a series of graphs basically showing some recent results arising from sort of the implementation of this arrangement, which has now been in place for a little over a year and a half. And so the HK45 as recently as February 2021 published some of the figures which highlight that parties have been quick to make use of and benefit from this interim measures arrangement. So as of February 2021, the HK45 has processed 37 applications made to mainland Chinese courts for interim measures under the arrangement. Of these 37 applications, 34 applications were made for preservation of property and assets. The vast majority were for asset preservation, 2 were for preservation of evidence, and 1 was for preservation of conduct. The total value of assets sought to be preserved across all of the 37 applications was approximately 12.5 billion RMB, or about a little under 2 billion USD. In each of the 37 applications, the HK45 issued a letter of acceptance, which was required under the arrangement, typically within 24 hours of receiving the application. On to the next slide, thank you. In terms of, just to give you a little bit more about the details of the applicants involved. So you'll see that 27% of the applications were made by parties from mainland China, with the remaining majority, 72%, being made by parties from jurisdictions outside of mainland China. Those were mainly applicants from the BVI, Cayman Islands, Hong Kong, Japan, Samoa, Singapore, Switzerland, and Taiwan. On to the next, thank you. In terms of some more information about the counterparties and the assets that are the subject of these asset preservation interim orders, approximately 60% of the applications concerned assets or evidence owned by mainland Chinese companies. 24% concerned assets on the mainland owned by non-mainland parties, those being from the BVI, Cayman Islands, France, Hong Kong, and Netherlands, and a smaller percentage, 16%, concerned assets owned by both mainland and non-mainland parties. The next slide. The next slide. In terms of the applications, in terms of the 37 applications received, they were directed to 17 different intermediate people's courts in China. The HKIC is aware of 24 issued decisions from these various intermediate courts, and of these 24 decisions, 22 applications for asset preservation was granted and 2 applications were rejected. So overall, these are quite encouraging results. One final point to note before I move on to the next topic is you'll see that the vast majority of these interim measures are for asset preservation orders. And the reason for that is probably because for mainland Chinese courts, it's perhaps a little bit easier to get asset preservation than it is to get evidence preservation and conduct preservation, because there's a relatively higher standard and a higher evidentiary burden associated with getting these. So for example, for evidence preservation, an applicant must prove that the evidence in question is at risk of being destroyed, or that it would be very difficult to get or obtain this evidence at a later point. In comparison, for asset preservation, it has traditionally been more straightforward to get and is more readily granted by the courts, provided that the applicant can first identify the asset, and second, that they can provide security for the asset preservation measure. However, given COVID, there has been some recent tightening of the standards applicable to asset preservation due to the COVID-19 pandemic. The Supreme Court in the PRC has published 2 guiding opinions in 2020. I believe one was published in April 2020 and one in May 2020, stipulating some instructions or guidelines for the granting of asset preservation orders. The crux of those guidelines is basically to instruct the courts in the PRC to more carefully consider applications for property and asset preservation in order to protect companies that are already under strain due to the pandemic. So to the extent asset preservations are imposed, there is a greater emphasis to ensure that they do not further hinder the respondent's ability to carry on their business. And the guidelines were issued, like I said, in April and May last year. And so it'd be quite interesting to see how that affects the implementation of this interim measures arrangement in the coming year or so. Thank you. On to the next topic, which is the supplemental arrangement concerning the mutual enforcement of arbitral awards. Next slide, thank you. So this supplemental arrangement was signed on the 27th of November, 2020. It amends or supplements the existing arrangement concerning mutual enforcement of arbitral awards between mainland China and Hong Kong, which was signed in June of 1999 and came into force in February of 2000. So most people should be fairly familiar with this particular arrangement since it's been in place for the past 20 years. It is the framework under which arbitral awards made in Hong Kong is enforced in mainland China and vice versa. For those of you who have actually gone about seeking to enforce a mainland Chinese award, you will also be familiar with Order 73, Rule 10 of the Rules of the High Court and the relevant sections of the White Book, which sort of set out and discuss the existing arrangement under the 1999 arrangement. In terms of the supplemental arrangement, it introduces 4 key amendments or 4 key updates, which I will further discuss on the next slide. So the first is more of a clarification point. If we could go directly to the next slide, thank you. The first is a clarification point, and that's in Article 1 of the supplemental arrangement. It clarifies that the procedures provided under the previous or the existing 1999 arrangement covers both recognition and enforcement of arbitral awards in Hong Kong and the mainland. So under the New York Convention, recognition and enforcement are viewed as two separate concepts. So recognition is the process of giving effect to and conferring binding status of an award by a national court, whereas enforcement is the national court's execution of the terms or orders set out within that arbitral award. But under the 1999 arrangement, it only uses the term enforcement, and there is no reference in that arrangement to recognition of arbitral awards, which has caused some confusion over the years. So the supplemental arrangement basically seeks to remedy this defect to bring the regime more in line with arrangements under the New York Convention, and makes it very clear that the existing arrangement covers both recognition and enforcement of arbitral awards. The second key amendment is the removal of restrictions that state that mainland awards must be rendered by certain recognized mainland arbitral institutions. So the 1999 arrangement is only applicable to mainland awards which were made by a prescribed list of recognized mainland arbitral authorities. The list is still relatively comprehensive, but there is still a list of prescribed institutions. So only awards issued by those recognized arbitral institutions could be enforced in Hong Kong pursuant to the arrangement. This restriction has now been removed with Article 2 of the supplemental arrangement. So it expands the scope of the arbitral awards that can be enforceable under the arrangement. And of course, this further aligns with the New York Convention, which focuses only on the place in which the award is rendered and less on the location of the arbitral institution. The third amendment, I think the key amendment brought about by the supplemental arrangement is allowing for simultaneous enforcement of applications or enforcement applications in both Hong Kong and the mainland. So under the existing 1999 arrangement, an award creditor must elect at the outset whether they want to enforce the award in Hong Kong or in the mainland. They're not able to pursue both in parallel at the same time. The effect of Article 3 of the supplemental arrangement is that they are now able to pursue both enforcement applications simultaneously in Hong Kong and PRC at the same time. So that's obviously very advantageous. The downside with the previous arrangement is that if you choose one jurisdiction, you choose wrong, and you're not able to recover as much as you had anticipated in that particular jurisdiction, you may run into problems later on when you come to enforce in Hong Kong, either because of limitation issues or because of dissipation of assets and so on. So I think this is probably the most important and consequential amendment arising from the supplemental arrangement. The fourth change is in Article 4, and this basically confirms the power of Hong Kong and mainland courts to impose post-award preservation and mandatory measures. Now, in terms of these four changes, the first and the fourth change, so Article 1 and Article 4, came into effect immediately upon signing of the supplemental arrangement, and that was on the 27th of November, 2020. In terms of the second and the third, so Article 2 and Article 3, and Article 3 is the most important one that I mentioned, which allows you to enforce simultaneously. They are not yet in effect. They will come into effect when the relevant legislation, in particular the arbitration ordinance, is amended. So that basically covers the two main topics that I'll discuss. I think the point is that under both of the arrangements for interim measures and also the supplemental arrangement for enforcement that I mentioned, they increase the attractiveness of Hong Kong as a seat of arbitration for parties intending to enforce arbitral awards against assets located in mainland China. So the HKIC remains, and because of this, and perhaps going forward as well, the HKIC will remain a very popular institution for international commercial arbitration disputes, particularly for China-related disputes. And I think that's reflected in the most recent 2020 statistics published by the HKIC, which shows record numbers of arbitration cases being handled, the majority of which are international commercial arbitration disputes. There are no specific figures that say how many of them are China-related disputes, but I think believe that the most telling statistic here is perhaps the number or the increasing number of Chinese language arbitrations that are being done before the HKIC. So the figure currently as of 2020 is about 20% of arbitrations either done exclusively in Chinese or using both Chinese and English. Thank you.
Thank you, Diana. We'll now move on to Paderi, please.
Thank you very much. Good afternoon, everybody. So I wanted to begin with just a brief bit of reassurance that I won't be speaking about Halliburton or Enka this afternoon, because those have been done to death. And in any event, we are trying to focus on Hong Kong cases today. So beginning with A, B, C, and D. Here an award was made in HKIC arbitration, and 3 months and a week later, A and B issued an OS to set aside. Now, 2 months later, and only 2 days before the hearing, they appear to have realized that they missed the 3-month deadline that's apparent in Article 34.3 of the model law. And so they issued a summons for retrospective leave for an extension of time. Now, in response, D asserted that there were no arguable grounds for set aside, and they sought an immediate dismissal. And perhaps controversially, D also argued that the court actually had no power to extend time under the ordinance, as Article 34.3 states an applicant may not apply after the deadline. Now, that point wasn't fully argued, but the court did note that in Sun Tian Gang, the court had already ruled that it could extend time, albeit that it would not do so without good reasons. And in this case, while the court did agree that actually the basis for the set-aside application was weak, it was the time limitation that disposed of the matter. The applicants had no real explanation for why the deadline had been missed. So irrespective of the fact that it was only 7 days, the summons was dismissed with costs on an indemnity basis, which just serves as a reminder to us all that actually diarising deadlines is extremely important. The next case to touch on briefly is A, B, C, and D. Here the case concerned the importance of correctly identifying the parties, and it's again an easy lesson. A, B, and C, D had entered into a contract. In that contract, A, B was defined as AB Bureau or any other affiliated entity. And 3 months later, they issued notice of arbitration naming the respondent as AB Bureau, and 3 months later amended it to AB Bureau, also known as AB Bureau Co. Limited. And then 4 months after that, they revised the name again to AB Engineering. On this occasion, it was because they had taken a view that AB's website suggested there'd been a restructuring, and Bureau is now known as Engineering. And this was also confirmed by 2 employees by email. Now, on this occasion, the arbitrator did not require that the submissions be reserved on AB Engineering. And when the award came out, unsurprisingly, AB Engineering sought to set it aside, suggesting that under Article 34.2a, the model law again, they were not a party to the arbitration agreement, and it had not been given notice either of the arbitration or the appointment of an arbitrator. And the court essentially did agree at all material times AB Engineering had been a separate company from AB Bureau. And although the contract referred to affiliates, the court considered that the body of the contract did not suggest that the parties had actually intended for the rights and obligations of the named parties that they should extend to a whole raft of unnamed affiliates. And that included the arbitration agreement. A second estoppel argument based on the fact that the employees had confirmed the change also failed because the claimant had filed affidavit evidence stating that they had relied on the website, which rather undoes the estoppel. The court also noted, applying Sun Tian again, unsurprisingly, that service of the notice of arbitration is, I quote, an important step in the proceedings, and that had not been done, at least insofar as AB Engineering. So finally, the court then also noted the well-established proposition that if you deny being a party to the arbitration agreement, there is nothing wrong with playing no part in the arbitration and seeking to set it aside at a later date. So that serves as a reminder to us all that the very, very easy step of well, hopefully easy step of make sure you know who your respondent is. So then turning to the two cases that I want to discuss in slightly more detail, SC and OE1 is the first of these. If I could have the next slide, please. Thank you. So here, a dispute broke out between two OE parties and SC relating to a supply agreement. And the award eventually concluded that SC was in breach and had to pay the costs of the arbitration. But then it becomes interesting because the award states that all other claim and relief sought by the parties is rejected. Now, OE had applied for a license and an injunction, and the tribunal had entirely failed to address those claims expressly. So OE sought a correction of the award under Article 33.1 of the model law, or a further award under Article 33.3. In both cases, on the basis that the omission to grant the relief is inconsistent with the finding of liability. And again, understandably, SC argued that actually the award did deal with those claims because all other claims were rejected. The tribunal therefore was functus. 2 months later, the tribunal did issue a further award and claimed to do so on the basis of Article 33.1 of the model law. In that award, that addendum, it confirmed that it had found against SC on liability, the relief flowed from the breach, and the tribunal had mistakenly omitted to provide a declaration for the relief sought. So SC sought to set aside that addendum under Section 81 of the ordinance on the grounds that the procedure adopted was not in accordance with the parties' agreement or the model law and was contrary to public policy on grounds of finality. And Madam Justice Mimi Chan considered the interplay between Article 33.1 and 33.3 and whether the tribunal was really functus and whether the award should be set aside or enforced. And as regards the interplay between the articles, the court confirmed that Article 33.1 is effectively equivalent to the slip rule. It's designed for a sort of mechanical correction of typographical mistakes rather than errors of judgment. And if you want an addendum or you need a further award, that should be sought under Article 33.3. However, the fact that the tribunal has the power is the key point here. It does not matter if the tribunal then incorrectly says that they are operating under Article 33.1, if in fact they have the power under Article 33.3. So as to whether the tribunal was actually functus, the court found that the award had set out a list of issues and analysed the arguments, but it had indeed failed to deal with the claims for a license or an injunction. So when read as a whole, stating that all other claims were rejected could not really be said to be the true intention of the tribunal to reject those claims that it hadn't turned its attention to. The tribunal therefore did have the power to deal with those issues as an addendum. The set-aside application was therefore rejected. Now, what is useful to note here is that SC tried to use additional arguments in its challenge to enforcement, which it had not used in its set-aside application. The court addressed this somewhat sternly and clarified that under the rules of the High Court, Order 73, Rule 5, subsection 4, subsection A, provides that an originating summons to set aside an award must state the grounds of the application, but that should be read as all of the grounds of the application. And while the parties do have the choice of remedies, i.e. they can actively seek to set aside the seat or they can passively challenge enforcement, in this case, what they had done is both. And by doing so, they had extended time by supplementing the set-aside application with further arguments at the enforcement stage. And Madam Justice Mimi Chan found that deeply unsatisfactory. She held that a deliberate decision to withhold arguments from a set-aside application only to use them later to challenge enforcement smacked of bad faith, was designed to obscure, procrastinate, and delay. It's fairly strong words. She found on that basis that they had waived their right to rely on those additional grounds and again awarded indemnity costs. So the key takeaway here, the key point, is the tribunal is not functus while it retains the ability to amend under Article 33. And that there is a power, provided the power exists under Article 33, it doesn't necessarily matter which basis you purport to act. And then finally, barring exceptional circumstances, do state all of your grounds when you apply to set aside. So the last case that I just wanted to turn to was Xiamen Xinjing Di. Now, this case started in 2005 and finally reached the CFA in August last year. And at a high level, the dispute is exceptionally straightforward. Eaton Properties agreed to transfer the shares in one of its subsidiaries to XXG and then had a change of heart and refused to proceed. So this went to CTAC arbitration, and XXG received an award that required Eaton to perform and pay damages for delay. Now, the problem was that by the time the award was issued, Eaton had actually undergone a restructuring which had placed those shares within a third party, so Eaton could no longer actually perform the award. A second problem was that Eaton's assets were in Hong Kong, so when XXG went to the local courts in Xiamen to enforce, that application was dismissed. So XXG then came to Hong Kong and applied under Section 2GG of the old arbitration ordinance, which is the equivalent of Section 84 in the present ordinance. Now, this applies an almost mechanical conversion of an arbitration award into a judgment of the Hong Kong courts. And while this remedies the jurisdictional problem, the specific performance issue remains. So XXG's solution here was to enforce by way of a common law action rather than under the statute. So in this case, they then sought specific performance of the award, specific performance as per the award, or a new claim for damages for non-performance. Now, the Court of First Instance, this failed wholly. But when it came to the Court of Appeal and ultimately to the Court of Final Appeal, it was quite successful. And the court firstly confirmed that actually the statutory mechanism for enforcement of awards does not prohibit parties from enforcing by common law action. The statutory route is more efficient, or is at least designed to be more efficient. And so there might be public policy reasons of why that could be preferred, but the common law route does remain open if parties are content to prove their case. Secondly, the Court of Final Appeal confirmed that when parties enter into an arbitration agreement, there is an implied promise to comply with an arbitral award. That's not particularly revolutionary, but the common law cause of action is a breach of that implied promise. It is not an enforcement of the award as such. The action is entirely separate and distinct from the underlying dispute. So when granting relief, the court is not limited by the relief that is actually awarded in the arbitration. So Eaton argued against that and said that given that continuation of the, performance of the underlying agreement had been awarded, an order for damages was contradictory. And this stems from Johnson and Agnew, which held that if a party doesn't comply with a specific performance order, the correct response is for the innocent party to seek termination of that contract and damages. The court clarified, however, that the concern in that case was to find consistent remedies in a single action. As this is a separate action, it doesn't apply. However, XXG was, of course, required to elect whether it wanted specific performance at common law or damages. You couldn't have both. So the key takeaways here are that parties are not bound to enforce awards solely under Section 84. There is a common law option, and there may be good reasons to do so. If you wish to do so, you will need to show a valid submission to arbitration, an award rendered in favour of the plaintiff, and the defendant's failure to perform that award. That's all I wanted to cover today. So with that, back to Felder.
Thank you, Pierre Derry. We'll hear from Sophia next.
Hi, good afternoon, everyone. I'd also like to thank HK45 for giving me the opportunity to speak to you all today. So for this part of the update, I'm going to switch gears a little bit and talk about something quite practical and something that will and probably should be impacting the way that we run our practices, and that's the Green Pledge to support campaign for greener arbitrations. Next slide, please. So what is this campaign? The campaign is an initiative that was spearheaded by an international arbitrator, Lucy Greenwood, and the campaign was founded in 2019 So the goal is to raise awareness of and mitigate the environmental impact, including the carbon footprint of international arbitration through behavioral changes. And it's targeted and it's encouraged that all practitioners within the arbitration community, including institutions, private practitioners, barristers, arbitrators, should participate in this campaign. Relevantly for us in Hong Kong, the HKIC signed the pledge in January 2021, and as an institution, it's been very active in promoting this initiative. So underneath the campaign, there is the Green Pledge, and what the Green Pledge is, it's a sort of a promise or a pledge that anyone can sign up to. Anyone in our arbitration community can sign up to, and it's a promise to support the objectives of the campaign and to put into practice the behavioral changes that the campaign recommends. So why is this important? Well, and what is the environmental impact of the international arbitration? For those of you who listened to the interview with Lucy Greenwood last year during the arbitration week, they reported on an initial study that the campaign had put out, which found that a large, medium-sized arbitration would require 20,000 trees to be planted in order to offset the total carbon emissions. I understand that this report is also being updated to include smaller arbitrations. So it will be interesting to see how the statistics for this report are going to be updated, and we're looking forward to the findings. So upon reviewing the conclusions of the report, the study revealed that just taking 3 key measures, which includes reducing the long haul travel for 1 return flight at each stage of the arbitration, eliminating hard copy filings altogether, and reducing the use of disposable sort of materials, especially disposable coffee cups, can have a significant or contribute to a substantial reduction in the carbon emissions associated with that arbitration. And these seem like small, doable measures. So there is a lot of incentive to see how these can be implemented in your practice. Practically, the campaign has issued a couple of documents that are supposed to act as guidelines for those who want to implement its initiatives. And this includes a framework, and associated with that framework are 6 protocols, and you can select from the framework and the protocols which changes or which guidelines will best suit your situation. So out of the protocols, and there are 6 of them, they are targeted at different groups. So for example, there is one green protocol for arbitral proceedings, which includes a model green procedural order. And the latter provides draft language which can be easily adopted by tribunals to implement sustainability measures during the conduct of an arbitration. Another protocol was targeted towards law firms, chambers, and those providing legal services. There's one specifically for arbitrators, for institutions, for hearing venues, etc. Next slide, please. So for the next slide, I will talk about the HKIC's initiatives. And for this, I would like to thank Kieran from HKIC, who went through some of the more recent initiatives with me over the phone in preparation for this presentation. The HKIC is a member of the campaign steering committee as well as its working group. And as I said before, it signed up to the Green Pledge earlier last year. So the HKIC has made significant efforts in recent years to enhance the sustainability of the arbitrations that it administers. And I've listed out 6 key measures here, as you can see. The focus really is on the 2 major sources of impact, which is reducing hard copy paper and reducing travel. So some of these measures includes storing documents electronically, submitting documents electronically, providing an online repository, comprehensive remote hearing services, guidelines for its marketing activities to minimize single-use items, eliminating plastics, adopting digital promotion for all events, and organizing events that promote remote participation for speakers and attendees to reduce travel to conferences, so much like what we're doing now today. Out of these measures, I think the online repository would be of particular interest to practitioners because what it envisages is a sort of online secure platform which parties can effect service through. Effectively, it's envisaged to be sort of like an e-filing system that some courts are currently have already adopted, and they are, I believe, still tossing up what's going to be feasible or what's going to be included in this service, but it may include things such as if a party uploads a document to the system, this would be sufficient for service, and you can amend exhibits, you can take out exhibits, you can download, it'd be secure. So we're looking forward to see how this can alleviate the need to send our exhibits via, each law firm's individual platform or by zip file or, of course, by hard copy filings. Next slide, please. So we can't talk about green arbitration without looking to the experiences from 2020. So one of the positives that came out of last year and came out of the pandemic was probably the way that it forced practitioners to find a new way of working that prioritizes technology and being efficient with resources, and particularly encouraging the use of virtual hearings and reducing hard copy filings. So I'll be talking a little bit especially about remote hearings. And remote hearings are particularly important for the green arbitration campaign because, as you recall, the 20,000 trees I spoke about a minute ago, 75% of those emissions are from long-haul travel. So the remote hearings would go a long way to helping the campaign. When we're talking about remote hearings, the overarching issue that we're always concerned about is procedural fairness and making sure that both parties are able to present their case. The Sino-Dragon case that I have up there on the slide was a 2016 case, but because of everything that went on last year, it had a resurgence in interest amongst commentators. So, and it's particularly interesting because of all the, it's kind of a highlight of all the issues that can go wrong during a hearing if there's not sufficient planning. And I'll speak to that if we have a little bit of time left. So in preparing for this presentation, I also looked through some of the rules and guidelines that the major institutions in Asia have put out. And virtually all of them have some form of guideline, either about remote hearings, either as part of their overall uh, guideline to manage arbitrations during the pandemic, so like the ICC or the HKIC, or some have adopted protocols that are specifically dealing with virtual hearings. So, for example, Singapore Arbitration Center. If you look through these guidelines, the most common themes that emerge include confidentiality, data security, cybersecurity, and these relate to both your hearing and your documents. So this would mean that you need to ensure that whatever platform that you're using the correct passwords, that the platform itself is secure. The second thing is clear video and audio connection. So the virtual hearing that you're planning to put on must be thoroughly tested before the actual hearing, and any technical difficulties that may occur, such as having a faulty camera, a microphone, bad internet connection, could disrupt or even jeopardize the hearing schedule. So with the Sino-Dragon case is an example, and during that case, one party who was appealing the award, who was trying to have the award set aside, said that when their witness was giving evidence, the platform that they were trying to use did not work on the first day. So they had to use a combination of Skype for the video and then a telephone or WeChat for the sound, which obviously is not ideal. The next one is preparing your e-hearing bundle, figuring out how you're going to display your documents and how you're going to share your documents. And this requires you to have a familiarity with how the platform works. You have to ensure that you have a backup plan if the virtual conference platform fails. And one thing that does come up is the hearing schedules to accommodate multiple time zones, especially for those doing international arbitration. This could be a difference between if everybody was in one place, a 5-day hearing, and if everybody was across different time zones, your hearing window per day is obviously has to shrink maybe from 7 hours to just 4 hours. So it would lengthen the time of your hearing. And a final word about part remote and part physical or part virtual, or what we also refer to as hybrid hearings. So these are the types of hearings where not everybody is in the same room, but also not everybody is online. Some participants may be in the same room and some may be coming in remotely. So in 2020, the HKIC reported that 70% of its arbitrations were administered virtually or partly virtually. And for a period during the first half of 2020, the majority was in fact partly remotely. And this may have an impact on the way that we practice, especially for the next 12 months, because as different countries are sort of opening up at different rates, we will probably be able to have some parties travel, but not all parties travel. So this again will come back to the question of if some parties can attend remotely, but some parties need to attend in person, is this fair? And what are the procedures that you're going to have in place to ensure that it is fair? The case that I've cited here is a Hong Kong CFI case. It's not related to arbitrations, but it does set out quite nicely the legal principles for deciding whether or not a witness should be able to attend remotely or in person, especially if other witnesses are not attending in person.
Thank you, Sophia. We'll hear from Hugh now.
Good afternoon. I'm here to cover enforcement of awards in Hong Kong and also the non-enforcement decision of X and Y. I appreciate I am the last thing standing before happy hour, so I will try to be brief. I'd like to focus on the non-enforcement decision just because it is rare in pro-enforcement Hong Kong and because there are some cautionary tales for us all. If I could have the next slide, please. I've gotten this chart from one of the leading textbooks here, and it sums up the enforcement process very well. So I just leave it here for your reference. I understand that the PowerPoints will be shared or made available after the presentation. In terms of cases, in view of the time, what I've done is just set out some of the key cases that really go into the principles on enforcement, and that's on the next slide. I'd like to draw your attention in particular to the first one, because in the very first paragraph, it actually sets out all the principles on enforcement one by one. So it's this one-stop shop research hub and really does save time, I would say. Anyway, moving swiftly on to X and Y on the next slide. Or rather the one after that. Yes. Okay, so the factual background is a little bit complicated and I've tried to sum it up diagrammatically. But the starting point is X Company, which is a Taiwanese life insurance company, and it set up a trust, AB Trust, in 2008. The relationship would be that it would subscribe for units in the trust in return, pay up funds, which were basically insurance premiums from its policyholders. Then part two of this tripartite investment structure is between the trust and the bank. So the trust would pledge the funds it gone from X to the bank as security for loans that the bank would make to X's subsidiary. Importantly, the pledge was governed by or is governed by Singapore law with disputes to be resolved by the Singaporean courts. And then to complete this triangle, what you have is a mandate from X to the bank to help manage X's funds. And the mandate made it clear that X could terminate it on notice, upon which the bank would have to return all the assets in the account to X. The mandate was governed by Taiwanese law with arbitration in the Arbitration Association of the Republic of China as the dispute resolution method. Now, with that relationship in place, and of course, the premiums as security, the bank then proceeded to loan $240 million to X's subsidiary. So you'll see that at the bottom of the chart. And as perhaps one might predict, the chairman of X company then misappropriated much of the loan. And he is now serving a 10-year sentence for fraud in Taiwan. Anyway, so in 2014, with all this, X company went into receivership and the receiver terminated the mandate and asked for the return of all the monies in the account. The bank returned some of it, but then it held up about $194 million as security, saying that this was what it was owed by the subsidiary in loans, and that it was entitled to hold this sum because of the pledge. Now, if we could go to the next slide, what predictably happened was that the receiver commenced arbitration in 2016 and an award was issued in January 2018 in favor of X. So the bank had to pay back the $194 million in spite of having held a valid pledge. The two reasons the tribunal came to or justified its decision on were firstly that the subscription to the trust, so the first part of that relationship, was outside the scope of investments a Taiwanese insurance company was permitted to do. And secondly, because the deployment of X's assets, and so therefore the pledge were questions of Taiwan law, and Taiwan law prohibits assets of an insurance company to be pledged to secure third parties' debts. That wouldn't work as well under Taiwan law. Then the tribunal went a step further to say that since both the subscription and the pledge were void ab initio, so the assets transferred to the trust by X remained X's assets all along, and so duly they could have them returned to them. So if we could move to the next slide. Armed with this award, then what happened was X sought leave to enforce here in Hong Kong. The bank duly applied to set aside the enforcement order. And the High Court here agreed on both grounds that were presented by the bank, namely that the award dealt with a dispute beyond the arbitration agreement and that the bank had not been able to present its case. Moving on to the next slide, on the first ground, this is where it gets interesting to note. The court made it clear what the approach was, which is that when you have multiple agreements with different dispute resolution clauses, and you want to see if the dispute falls outside a particular clause, you figure out what the dispute actually is about first, and then you see which clause or which contract has the closest connection with the dispute. In other words, where does the center of gravity of the dispute lie? Now, the court specifically deprecated the House of Lords Fiona Trust presumption that parties are likely to have intended any dispute arising out of their relationship to be decided by the same tribunal. It said that this does not apply when you have multiple related commercial agreements with jurisdiction clauses governing different aspects of the relationship. And it said this is true even if what it means is that you will have a risk of fragmentation of the overall dispute resolution process. So some part of the dispute may be tried in one place, whereas some other parts of the dispute may be tried in another place. That's just an inevitable consequence of what the parties have agreed. Anyway, then applying all of this, what the court said was the real dispute here was not about the termination of the mandate, which would be governed by the mandate, but there was no dispute that X had the right to cancel. But what the dispute was about was whether the bank could rely on the pledge to retain the assets upon the cancellation. And that depends on the validity of the pledge, which the parties had expressly agreed, as you may recall, to be determined by the Singapore court using Singaporean law. So the fact that the pledge is illegal under Taiwan law may affect how the Singapore law or Singapore court sees it, but it's only the first step in the analysis. What the court said was that after having found the pledge was illegal under Taiwan law, the tribunal did not have the jurisdiction to determine that the pledge was illegal per se. And what it should have done was refer the question of the pledge's validity to the Singapore court. And so because it had overreached on a critical matter in the dispute, enforcement could not be allowed of the award. Now, if we move to the next slide, we'll see the second ground that the court dealt with, which is that the bank had been unable to present its case. The court started by emphasizing that if the complaint concerns due process, the situation must be serious or even egregious. The court can refuse to set aside if the error was not material to the outcome. Now, there were two problems here. The first is that both sides' Taiwanese law experts had agreed that the breach of Article 146 led to fines rather than voidness of the investment. And because both sides had agreed to it, the bank did not challenge the point. The second problem was that it was only in the post-hearing brief that X argued for the first time that breach would lead to voidness and not just fines, which meant that even if the bank had wanted to challenge, it could no longer challenge because everything was pretty much done. The tribunal then rejected the expert's common view, and on the basis of the post-hearing brief submitted by X, found that Article 146 did void the investment, and it was not just a matter of fines. The court in Hong Kong then said that the bank had not been given a fair opportunity to comment on whether this Article 146 had led to voidness, and whether such voidness under Taiwanese law was sufficient to dispose of the bank's rights under the pledge. And so therefore, the award had to be set aside on this ground as well. Now, let me move to my last slide, which is talking about the lessons to learn from this case. I think probably starting actually from point 3. And that is, the court accepted that tribunals don't need to point out each and every aspect of a claim or evidence that they don't agree with. But for matters which have never been an issue and which will feature significantly in the decision, the tribunals should really take care to ensure that full opportunity has been provided to the parties to comment. Now, X had actually said during the court application that at the end of the hearing, there was a discussion on post-hearing briefs, and the tribunal had in fact invited parties to address them on the validity of the trust subscription under Taiwanese law and the effect of a violation. But the court in Hong Kong said that was too general. There had been no indication from the tribunal that it intended to reject the experts' common ground or that the validity of the pledge could be determined on the basis of Taiwanese law alone, even though the pledge had expressed itself to be governed by Singaporean law. So if you're an arbitrator and you are going to go against an agreed position on issue A, and issue A is important, then you can't just say to the parties, look, make sure you guys say something on issue A. It would seem from this judgment that you need to say, I actually disagree with both your positions on issue A, and please say something about that specifically. That is a relatively high threshold, actually, if you think about it, and difficult practically, because it's usually only after the hearing, when you've looked through everything as an arbitrator, do you know what your actual position on issue A would be. And what this in effect means that if that is the case, you probably will want to ask for supplemental post-hearing briefs to address the point specifically. The second thing, lesson to learn, sorry, back to the previous slide, actually, yes, is that the court reiterated in setting aside applications, it does not look at the merits or the correctness of the tribunal's decision. But the reality is when the ground is jurisdictional overreach, you will have to, the enforcing court will have to look at what was argued and what was ruled on. So the court here, for example, said the tribunal should not have found the pledge was illegal just because it was illegal under Taiwanese law, and should not have said illegality meant voidness. That really, it's hard to say that's not commenting on the correctness of the reasoning. So what I would say is that as a lesson, if you are an arbitrator, don't assume that just because there's no appeal on the merits, you'll be safe, because sometimes in effect, there is an appeal-like scrutiny to your award, so do be very careful what you say. And then if you're defending a challenge to enforcement as a party, work out what sort of reservations you need to build in, because of course, although rules do vary, you'll see in this case, the bank will probably take this judgment to Taiwan and take it to Singapore and say, well, the court in Hong Kong made that sort of finding. And even if the judgment in Hong Kong isn't res judicata binding, then there will be arguments that there should not be inconsistent findings, or comity dictates that we should respect this judgment, and so on. And lastly, the last lesson I'd say is that we often assume that our arbitration clauses are drafted very widely, and therefore any dispute would fall into them. But it's clear that that's not good enough where there are multiple agreements. So even if the dispute could arguably be said to fall within clause A, if it falls more within clause B, then it will still be clause B that prevails. And so one has to take care when you're in a multiple agreement situation. I think I'll end there. Thanks very much.
Thank you, Hugh. We have time for some quick questions. Perigay, this is to you. With regard to A, B, C, and D, do you think the outcome could have been different if the plaintiff's case or set aside had been stronger?
Yes, absolutely.
Oh, your microphone.
Thank you. Yes, absolutely. The court retains a discretion to allow time to be extended. In this case, the grounds for set aside were quite weak, but the court's not really in the business of furthering injustice. And so if there were good grounds, I'm sure that would be a different outcome.
Thank you for that. Last question to Sophia. If someone does want to find out more about the Green Pledge and get involved, how can they do that?
So I believe the best way is to go on the campaign's website. You can just Google campaign for green arbitrations or Google Green Pledge, and it will take you there. The website's quite informative, easy to navigate, and has a lot of good information.
Thank you, Sophia. And thank you to all our speakers today for joining us, and also our participants for listening to this very interesting discussion. If you haven't joined the HK45 group, please do so. We have many events, and we look forward to seeing you next. Thank you. Bye.